Each national partner conducted desk-based research and the legal framework and academic literature in their country. The partners also reviewed approximately 10 case files on court judgments and interviewed up to 10 defense lawyers, prosecutors, and judges. Finally, in this project, it is also important for us to look into the theoretical foundations and principles that should guide the judicial decision-making on whether or not to exclude unlawful evidence. This research, which was conducted by Catholic University of Leuven, which you'll also hear in the first panel, is at the basis of our main recommendation, a methodology that we offer for discussion in hope that it could provide a principled guidance to the courts on how to deal with unlawfully gathered evidence. I will briefly guide you through our main findings of the regional and domestic practice, as well as our key recommendations. We looked on the regional level, we looked mainly at the European Convention of Human Rights and EU law when analyzing admissibility of evidence and evidentiary remedies. In the EU in particular, at the moment, there is no legislation on effective remedies. There is a right to effective remedy, but there is very little guidance on what this remedy should be. So it is often impliedly believed that European Court of Human Rights case law will fill in all the gaps and that it will provide sufficient guidance to national courts. Our research, however, shows that in practice, this is not quite the case. Based on the role and the principle of subsidiarity, the ECHR largely leaves the exact rules of admissibility to national law. But there are some cases, of course, where the court requires exclusion of unlawful evidence, and these are three. Firstly, the evidence obtained by torture or inhumane, cruel, or degrading treatment. Although there is a caveat in this point that with the regrettable case law in case of Gafgen versus Germany, allowing evidence obtained indirectly from inhuman and degrading treatment to remain in the case file and to be used in some capacity in a criminal case. Secondly, where the court requires exclusion of evidence is in cases where the illegality or the violations of procedural safeguards in evidence gathering have rendered the evidence inaccurate or unreliable, or there are doubts about the reliability of evidence. And the third case where evidence is required to be excluded is evidence that results from entrapment. In all other cases, the European Court of Human Rights applies the so-called overall fairness tests, which is a non-exhaustive list of criteria the court uses to establish whether the criminal proceedings as a whole have been fair. It also contains some questionable criteria, such as public interest in the prosecution. In our view, this criteria seems to imply that standards of adherence to the rule of law in evidence gathering may be lower where there's increased public attention to the prosecution. Within the overall fairness test, the court does recognize that the exclusion of evidence is key means for national courts to provide an effective remedy. In principle, the court states that where the exclusionary rule is applied, it is unlikely that there will be a violation of the right to a fair trial. In practice, however, unlawful evidence, even where it plays a decisive role, is often tolerated by the court, and this is particularly true with violations of the right to private life. In those cases, the court gives more decisive role to the reliability of evidence than its legality. These violations of the right to private life include unauthorized surveillance, search, or data gathering, where the accuracy of the evidence is rarely in doubt. So the overall fairness test is the difficult one to fail when the violation concerns right to a private life. With regard to defense rights, the situation seems to be slightly less clear. For example, in case of right to access to a lawyer, The court made a principal stance in 2009 Saldus case, which subsequently served as a basis for EU directive on access to a lawyer. This standard has been significantly softened in the subsequent line of case law, allowing the evidence obtained through a deliberate violation of this right to still be used in criminal trials. In practice, the court does find a violation of right to a fair trial in many cases where evidence has been obtained because the suspect didn't have a lawyer in early stages of proceedings. At the same time, there are also cases, such as relatively recent case in Perugia versus Malta, where extensive and systemic failures in providing access to a lawyer, even when combined with other procedural failures, have not led to the conclusion that the proceedings as a whole were unfair. On a procedural level, both the EU law and the European Court of Human Rights require defendants to have access to a fair procedure in national courts to be able to challenge reliance on illegal evidence. In practice of assessing that procedure, it is unclear, though, whether the courts look into key aspects of this right that I will highlight in a minute when we will speak about domestic law and practice. For example, whether the defense has meaningful access to information about evidence gathering process, whether the evidence is able to challenge evidence early on to prevent further evidence from being gathered in the case on the basis of that violation. So the conclusion is, in those cases, that the practice of national courts, of the regional courts, as Judge Pinto de Albuquerque and Bojnak has put, is incoherent and lacks clarity and needs to be revisited. National courts rely on that regional practice for it's too flexible, so it can be used either to support more principled view or to allow for unlawfully gathered evidence to be admitted into a criminal case. Diversity of legal practices. I'll move on to the domestic practice. And what we have observed first and foremost is that the laws in EU member states vary enormously. Some states, such as Croatia, choose to have a detailed legislative guidance on exclusion of illegal evidence. Others, such as Lithuania, have very few rules, and Sweden has almost none. This may be because there is a different legal culture and differing understandings as to what should be the balance between the choice of legislator and the discretion of judge when it comes to excluding or admitting and using illegally obtained evidence. Over the past decades, legal changes in several member states have increased the level of discretion the judges have to admit illegally obtained evidence. And to give you one example, I'll share the screen. To give you one example from Poland is Article 168A, which was introduced a couple of years ago. And the law outright states that violations of law or even prohibited acts in evidence gathering are not basis for exclusion. There's also an observable trend that sets lower evidentiary standards where the accused are charged of serious offenses. This is the case, for example, in Croatia and also in Ireland, where special criminal court applies different rules in cases that deal with organized crime and terrorism. Legal systems give judges broad discretion to decide whether to admit unlawful evidence. And in practice, it is normally used to admit the evidence rather than to exclude. So just show an example. Even where there is a seemingly clear obligation to, even where there's a seemingly clear obligation to exclude evidence, in practice, judges interpret the law to introduce conditions such as substantive violations. Sorry, I'm just switching between. So in practice, there's where there's seemingly clear obligation to exclude evidence, judges interpret the law to introduce conditions such as substantive violations or fundamental breaches to allow flexibility and reliance on the legally obtained evidence. There is evidence of judges relying on regional and international human rights standards to justify the exclusion of illegal evidence. But there are also cases of judges relying on the ECHR case law, in particular to overall fairness test, to justify a less strict approach to evidentiary remedies. Although there are major benefits to allowing evidential challenges pre-trial, it is in most countries, this is not possible or is ineffective in practice. This is partially because there's either a general lack of procedure to challenge the legality of evidence pre-trial, as is the case in Lithuania, or the defense does not have early access to case file and specifically to information on how evidence was gathered. Investigative practices, such as informal questioning in the absence of a lawyer, or information about rights, are particularly problematic as they are undocumented and unrecorded in any way. But these violations and evidence gathered as a result can be very instrumental to building the prosecution's case. It could be either by gathering further evidence or using that information that was obtained illegally beforehand in subsequent interviews to obtain the same information in a legalized way. Sometimes inadmissible suspect statements are included indirectly through police testimony about those statements or informal memos. With a few exceptions, such as Croatia and Ireland, which has jury trials, challenges to the legality and use of evidence normally takes place at the trial stage before the same judges who will decide ultimately on the guilt or innocence of the accused. This means that they will examine the unlawful evidence and are most likely to be influenced by it, regardless of whether they will eventually rely on this evidence in their official written decision. So that is the overview of the domestic practice. And against that background, we developed recommendations. And the most important recommendation that I want to briefly show you today is the methodology that we offer for a discussion, because it could probably be discussed and worked on further. And we very much hope for it to be used as a starting point. So to briefly show you the methodology that you can also find in the report at the conclusions section, it incorporates the work of our academic partner, Catholic University of Leuven, on principles, the guiding principles and rationales that should be used to assess and guide the decision of whether to exclude or admit illegally obtained evidence. And it follows through three filters that should be assessed when judges are faced with evidence that is established to be obtained through a violation of procedural safeguards or fundamental rights. This methodology incorporates, it's not new, it incorporates already findings of extensive research of existing assessment from European Court of Human Rights, from Supreme Courts of member states, and also, as I said, the theoretical foundations on principled approach on illegally obtained evidence. And to shortly guide you through is the first point of assessment is the reliability. One of the main functions of, and the main function of truly in criminal proceedings is to establish the truth, to see whether a criminal offense has happened, who is guilty, whether a person who is accused is guilty of the criminal, has actually committed the criminal offense. And under this step, the judges are invited to verify whether the manner in which the evidence was collected, in particular the violation of legal rules governing the evidence gathering process, caused doubt on the accuracy and reliability of evidence. If there are any doubts about the reliability and accuracy of evidence, it should be excluded. One obvious example, of course, is evidence obtained through torture, which has been declared by European Court of Human Rights to be inherently unreliable. The second filter is protective filter, and it's designed to prevent undue prejudice to defense and remedy any adverse effects that there can be from a violation of rights in evidence gathering process. This requires the courts to go into more detail than they do right now, to evaluate the impact of the illegality of illegally obtained evidence on defense or fairness of the proceedings. First, the judges should verify whether the defense has been able effectively to challenge the legality. This includes access to materials, clear procedures, chances to present arguments, and how early on there is such possibility. Secondly, they have to assess how the illegally obtained evidence affected the fairness of the proceedings. And here, there are multiple criteria that we propose to take into account. The stage of proceedings this happened, the violation happened, the earlier the impact is likely to be bigger, the nature of violation, impact on development of the further case, whether this information was used in, for example, suspect interviews. If the inclusion of the illegally obtained evidence would make a fair trial impossible, it should be excluded. Example could be where a suspect has given incriminating statement while being denied access to a lawyer. Assessment of legality and effective remedy should address not only the statement itself, but the broader impact of the violation. If the statement is subsequently repeated, it should be verified whether subsequent interviews relied on this information, whether there was meaningful access to a lawyer, whether suspect's rights and the admissibility of previous statement was clearly explained, and other factors such as those. And the third filter, which we invite judges to take into account and to assess, is to check whether the admission would not compromise the integrity and legitimacy of a fair trial. And there are several interests to assess in this step. The respect for the rule of law, meaning whether there are deliberate violations of legal rules in evidence gathering process, whether prevention of abuse, the prevention of interest in prevention of the abuse of power, and the need to prevent further police or prosecutorial misconduct by regularly benefiting for these sorts of practices, protection of integrity and legitimacy of criminal justice, and maintenance of public trust in criminal justice system. For example, where there is a well-established systemic practice of conducting informal interviews in the absence of a lawyer, exclusion of all evidence obtained and derived from such practice may be necessary to prevent systemic police misconduct and maintain trust in in the criminal justice system. We have also developed a more specific recommendations for different actors on regional and national level. And you can find them at the bottom, at the last part of our report. And we are happy to discuss them and answer any questions during the event. Thank you very much for bearing with me through this short introduction of our findings. And if you have any feedback, you can find our contacts in the report, and please do let us know and debate with us on the findings and our proposals, the methodology. We'll be very happy to hear from you as practitioners or academics or anyone else who is interested in the findings of our report. Let me move on now to our first panel, and I'm very happy to introduce three distinguished speakers that are with me on the panel. As I said, this panel is intended to kick off the event by discussing the main findings of the regional report, and the panelists will discuss their research and practical experience on the availability and effectiveness of evidentiary remedies. In particular, we hope to focus on theoretical aspects of evidentiary remedies in the practice of the European Court of Human Rights and national courts. So without further ado, I will introduce the first speaker, Professor Pinto de Albuquerque. He was the president of the Committee of Rules of the European Court of Human Rights and the president of Criminal Law Group at the court. The focal point of the international relations of the European Court with the constitutional and supreme courts outside Europe. He has previously worked as an anti-corruption leading expert in the Council of Europe and as a full professor at the Faculty of Law of Catholic University of Lisbon. He has published 23 books and more than 65 articles and book chapters in various languages. Since his appointment as a judge in Strasbourg, he has authored 157 opinions that have significantly contributed to development of international human rights law. And we have quoted, as you have seen, also in the first part in the presentation, one of his opinions in our report. So thank you very much for being with us. And the floor is yours for the following 10 minutes, 12 minutes. Thank you.
Thank you so much for the invitation. It's a pleasure to be with you. My point will be the following. My view on the key questions that you have enumerated on the agenda is very clear. I don't think that the ECHR case law effectively addresses and remedies violations of defense rights for two reasons. First, evidence that has been illegally obtained can be admitted in the case file and used for conviction purposes. And second, a trial can still be deemed fair if the conviction is based on illegally obtained evidence. For these two reasons, basically, I think that the current evidentiary standards of the ECHR do not fulfill the objectives of an effective remedy, including for the prevention of future violations in evidence gathering process. So this is my very straightforward answer to your key questions. For the motivation of this, I will sum up what I've written in two separate opinions, which are exactly on this specific issue. I refer to Dragos Ioan Rusu versus Romania and Murtazalieva versus Russia. It is true that the court has dealt with complaints alleging that the use of a particular item of evidence in criminal proceedings violated the principle of fairness of the trial throughout the years. This is not new. The court has regularly stated that the convention does not lay down any rules on the admissibility of evidence as such. This general statement has produced very problematic results. especially where the evidence in question has been obtained in breach of rights and freedoms protected by the Convention, and particularly those rights guaranteed by Article 6 and 8. The court has consistently rejected the argument that proceedings leading to a conviction on the basis of evidence collected in breach of Article 8 of the Convention were unfair, and that consequently there had also been a violation of Article 6 of the Convention. This position has been criticized by many dissenting judges, and I strongly agree with these dissenting judges. Some of these opinions have mentioned the contradiction, the inherent contradiction in the position of the court, because when examining Article 6, it departs from its own conclusions on Article 8 or 3, even in some times. Less frequent, but also it has also been the case. Some of these opinions pleaded for the inadmissibility of the evidence obtained in breach of the rights and freedoms guaranteed by the Convention, based on the argument of the effectiveness of the Convention rights. For instance, Judge Lokaidis in Cannes wrote, "If violating Article 8 can be accepted as fair, then I cannot see how the police can be effectively deterred from repeating their impermissible conduct." This should be obvious. In my view, it is obvious, but it has not been the position of the court. The majority of the court does not follow this view. Indeed, other alternatives, such as the possibility of disciplinary proceedings against state agents violating a convention provision or a civil action in damages against the state, cannot offer a remedy comparable to the exclusionary rule of inadmissibility of evidence obtained in breach of the Convention. Evidence for the purpose of criminal proceedings against a suspect is often obtained by interference with rights and freedoms guaranteed by the Convention. These actions do not constitute a violation as long as they, of course, are compatible with the requirements of the Convention itself, like, for instance, those set in paragraph 2 of Article 8. The purpose of these requirements is to ensure a fair balance between the rights of individuals and the interests of society. This is what Article 8, paragraph 2 is about. To put it simple, as Judge Spillman wrote in Bikoff, if something that is prohibited by one provision, like Article 8, then it should not be accepted under another provision like Article 6. This is the inherent contradiction in the reasoning of the majority. The court's position has been that the question to be answered is whether the proceedings as a whole are fair. My point is that this position does not take into account the difference between evidence obtained by a simple breach of national law and evidence obtained in violation of rights and freedoms guaranteed by the Convention itself. More importantly, this court's position ignores the existence of absolute bright red lines in criminal procedure. This is the core of the issue. For me and the dissenters, there are in criminal procedure absolute rules which, when violated, taint the entire procedure. And there is no way to cure the procedure if these rules are not complied with. So these red lines, they should be effectively respected. Otherwise, the whole procedure is null and void of any effect. The court's position when arguing on the basis of this overall fairness assessment ignores the existence of these red lines. It allows these red lines to be crossed with the end result of undermining fundamental rights and freedoms in a state governed by the rule of law. These red lines, these absolute rules, should be complied with and should lead to the necessary exclusion of evidence collected in breach of them. And when they are in fact not excluded, when they are invoked by the judge or by the court in order to motivate its decision, then the decision is absolutely null and void. In its assessment of the overall fairness of the proceedings in the light of the admissibility of the evidence, the court outlined in the Grand Chamber case Bikov some criteria. If you read this criterion, it's very, very vague. And in fact, it allows for a lot of discretion to the state. These criteria do not lend themselves to easy comprehension and applicability, and therefore do not provide clear guidance to the national courts. One can wonder whether these criteria are exhaustive. It seems that they are not. Furthermore, it's not clear whether they are to be considered cumulatively or alternatively. But above all, they focus on the probative power of the disputed evidence, which is very dangerous. Ultimately, according to the Bikov criteria, as long as a piece of evidence is important enough, its use is fair. This is a totally opportunistic approach to the issue of evidence collection. I do not agree with this purely casuistic, opportunistic approach. Often, evidence obtained in breach of the rights and freedoms guaranteed by the Convention is highly important, no doubt, of course. Important for the prosecution, important for the police case. And there may be cases where it is authentic, even reliable and accurate. These two should not mean that the court should be less demanding as regards compliance with the Convention. The evidence can be authentic, can be reliable, can be accurate, but if it does not comply with the requirements of the Convention, namely paragraph 2 of Article 8, then it should not be taken into account. Equally, the opportunity of challenging the use of specific item of evidence depends on the provisions of national law, which in turn should not influence the autonomous assessment of fairness under Article 6(1), which the court is entitled to undertake. One thing is national law, another thing is convention law. And to mix the two, it only makes the life of the judge, especially the international judge, much harder. So I believe that the court's case law falls short of the consensus amongst the majority of the contracting parties. And this consensus goes in the sense that the use of evidence obtained by violation of human rights and fundamental freedoms should be prohibited, save in very exceptional circumstances. If you do a serious comparative law review of the situation of the contracting parties to the Convention, you would come to this conclusion. The issue of the admissibility of evidence obtained in breach of fundamental rights and freedoms has drawn the attention of many experts. There exist legal systems with an absolute exclusionary rule, according to which any item of evidence obtained by such violation must be excluded from trial as a matter of principle. This principle, and this has been stressed by so many experts, this principle possibly extends further to evidence derived from such evidence, the so-called fruits of the poisonous tree. There may be several exceptions to the exclusionary rule, according to the doctrine. Its imperative is sometimes weighed against the public interest. Some legal systems, again, described by many experts, apply the concept of the nullity of the investigative acts performed in breach of important provisions of national law instead of the exclusionary rule. But it would be hard to find a system in which the admissibility of evidence is dependent solely upon the probative value of the evidence in question. That is to say, the criteria identified by the court in Bikov. This is all the more understandable in the light of the nature of criminal procedure. In order to establish the relevant facts of the case, the authorities may need to resort to investigative methods that interfere with the rights and freedoms of the Convention. This is clear. But seeking the truth is not the only aim of criminal procedure. Protecting the individuals against the unlimited, disproportionate, or arbitrary use of repressive powers by the state in criminal law is of equal historical importance. The court's jurisprudence after the BCOP shows that the application of the criteria developed in this case has never led to a finding of a violation of Article 6. This is very curious. This is in itself very problematic. It raises the issue whether the criteria, the BCOP criteria, are balanced. They were found implicitly to be insufficient in Prade, where the chamber, deciding on the application, examined the following issues: the nature of the unlawfulness, the existence of an effective opportunity to challenge the use of evidence, the level of intrusiveness, the quality of evidence in question, the importance of the disputed evidence for the criminal conviction of the applicant, the weighing of the public interest in the investigation, and conviction against the individual interests that the evidence be gathered lawfully. It is not my intention to analyze in depth the judgment of Prade or to take a stance on the conclusions of the chamber. The purpose of reminding this case is to show that the case law on the matter is far from settled. The criteria mentioned in Prade are nowhere to be found in BCOP. Some of these criteria are totally new, which means that the court is not coherent with itself. And remember, BCOP is a grand chamber case, so it makes no sense that the chambers innovate in relation to a grand chamber case. Why do they need to innovate? Because they feel that BCOP is insufficient. And they bring into play elements that do not relate solely to the probative power of the disputed evidence. This is precisely what is the added value of this chamber development. Nevertheless, they still leave much room for development in terms of coherence and clarity. Furthermore, they possibly still fall short of the standards frequently applied in modern comparative criminal procedure. In sum, the court has yet to determine the question of principle here at stake. If and in what term can evidence obtained in breach of any convention right, namely Article 6 or 8, is permissible, if the use of this evidence is permissible, and if a conviction can be based on such evidence. This question goes to the heart of the concept of fairness of criminal trials. It is also of general importance for the effectiveness of the protection of human rights in Europe. I think for the purpose of this event, we should stress that as lawyers, I myself am a lawyer, we should plead for a change of the course of the case law. This case law does not protect the interests of the defense and the prosecuted person. So it is extremely insufficient, extremely, how should I put it, arbitrary. This is the word, and it cannot be avoided. It is so vague, it's so uncertain that it becomes arbitrary. The applicability of the BCOP criteria, and we could talk also about the Ibrahim and others criteria, which is even worse. BCOP regards violation of Article 8 guarantees, but Ibrahim regards even more sensitive issue, a violation of Article 6.3 guarantees. How can you ground a conviction on evidence obtained in violation of Article 6.3? It says as if these were not really provisions of the convention. They are totally disregarded and dissolved in this overall fairness assessment. So, to sum up and to conclude, my point to you today is that lawyers should be very attentive to the developments of the case law of the court, to the practice of the court. They should be very critical. It is not a case law where we could say that it promotes the fairness of the criminal trial. Unfortunately, we have to conclude this. It does not promote, the current case law of the European Court does not promote the fairness of criminal trials. And it is up to us as lawyers and professors to change this situation by pleading cases before the court, by arguing on papers, on conferences, on blogs, that there must be a change. There must be a change. This course of the case law is entirely inadmissible and in effect does not provide the legal certainty that is required from Strasbourg. To end on an optimistic note, there are some developments at the level of the chambers, which are in some way revolting against the statements of Ibrahim and Bikov, and these are to be applauded. These developments at the level of the chambers, I mentioned Prade, but there are some other cases where the court at the level of the chambers is indeed sending the message that the case law, the Grand Chamber case law, is not sufficient. And this is to be applauded. It is on the right course, on the right direction, and I hope that the court ultimately will one day review its Grand Chamber statements in Bikov and Ibrahim and others, and will finally come up with a case law that is more sensitive to the interests of the defense. Thank you so much for your attention.
Thank you so much, and for your intervention. And it really goes together with what we have found in our reports, and we have also called on lawyers to actually act and to plead the cases. And the worrying issue is that the ECHR practice is looked at least in the EU level, at least to assume that it's going to fill in all the gaps that lack of legislation has left, or maybe that are unclear in the national laws. But we have also concluded that there is a casuistic approach, and it's not a principled approach. It's a very case-by-case approach, which the courts, and we put the quote from Swedish report, can use one or the other way to either justify or restrict use of unlawfully obtained evidence in criminal cases. So thank you very much, and we hope for discussing these points further in our discussion. And I will give the floor now to Marcin Volny, who's been our partner throughout this project. And he's an attorney at law and has graduated from the Faculty of Law and Administration of the University of Warsaw. And since 2010, he's with Helsinki Foundation of Human Rights in Poland, and he was the lead researcher on the national Polish part of the project. He's an expert in criminal law and juvenile justice system, as well as penitentiary system, an author and co-author of various publications regarding human rights. Marcin, the floor is yours.
Thank you, Ilza. I will share the screen. I'll start the presentation. Thank you for the invitation. It's always a pleasure to join a panel on such meaningful topic. In the next 10 to 12 minutes, I will try to bring you a bit closer to Polish regulation concerning the admissibility of evidence. Well, sorry, it happened too quickly. To start with, just a quick glance into the regulation before 2015. A Polish Code of Criminal Proceedings is generally based on the principle of free evaluation of evidence. During criminal proceedings, it's generally permissible to carry out any evidence collecting except for those that are prohibited by law. Before 2015, the code did not have specific provision on the inadmissibility of evidence collected with violation of law. However, the standard in that field was confirmed by the jurisprudence of our courts. Courts interpreted the standard from the specific provisions of the Constitution. For example, the rule of law principle, the principle of legality in state actions, or specific human rights protected by our Constitution. Those provisions were used in several landmark cases to prevent the admission to the proceedings and evidence that was obtained with a violation of law. In the picture, you can see a quote from our Supreme Court ruling issued in a case of one of the MPs accused of the bribery. The MP was acquitted during the trial when it turned out that she accepted the bribery during an entrapment of anti-corruption agency mounted with a violation of law. They did not have any evidence suggesting that the MP have previously committed any crime. So there was no legal grounds to initiate secret operation against that MP. This case and several other important cases originated from the years 2005 to 2007, where the law and justice was enforced in Poland. And please keep that in mind when we will be discussing the future amendments to the law. The situation in the field of evidence admissibility significantly changed in 2015 with the entrance into force the huge reform of criminal proceedings. The reform generally shifted the proceedings to more adversarial approach, and one of its consequences is that it included also specific provision referring to the problem of evidence admissibility, evidence obtained with violation of law. It prohibited to use pieces of evidence obtained for the purpose of the proceedings by a forbidden act, which means that whenever the crime was committed in order to obtain evidence, such piece of evidence should be found by the court inadmissible. But only a few months later, after the reform, the government has changed, and the new government, Law and Justice government, decided to withdraw from the reform. The amendment to the Code of Criminal Proceedings modified also the wording of Article 160A, which Ilse has previously referred to. It established some kind of reversed evidentiary prohibition. The intention of the legislator, clear intention, was to force the courts to admit vast majority of evidence that were obtained with a violation of law. Not only with the violation of law, but also through a forbidden and prohibited act. Even if that act concerns threats, soft violence, for example, slapping the person who was interrogated. As you can see at the bottom of the screen, the catalog of possible exceptions to that provision is quite narrow. Fortunately, we still have some independent courts in Poland, and the courts interpreted this provision in totally different way. They weakened its meaning. In several judgments, they have used the position of a comma in that sentence or the word exclusively to totally modify the meaning of the article. To give you an example, the Court of Appeal in Wrocław invoked that the word exclusively declares that the evidence has to be considered inadmissible each time it was obtained in violation of law or by forbidden act, and when such violation or the commission of a crime is combined with a violation of the Constitution. In another case, the Supreme Court has taken a slightly different approach and emphasized the impact of a given piece of evidence on the overall fairness of the proceedings. The court held that Article 168A cannot constitute a legal base for admitting an evidence obtained in violation of the rules of procedure or by prohibited act, if the taking of such evidence would render the trial unfair in the meaning of Article 6 of the Convention. However, we have to remember that those are only court judgments. They are not a source of a law in Polish legal system. Its authoritative force is only based on the persuasiveness of the arguments used and the authority of the court. At any moment, it might happen that another court or another judicial bench of the Supreme Court will reach totally different approach and totally different conclusions. Therefore, the defendants in Poland are still at risk that the court in their case will use the original interpretation of this provision, the one that was consistent with the intention of the legislator. Moving on, one of the project goals was to assess whether the national legal systems guarantee individuals with a right to effective remedy in the field of evidence admissibility. In our criminal proceedings, there is no specific incidental procedure allowing the parties of the proceedings to challenge the decision of evidence admissibility. So the decision of the court to admit evidence or find evidence inadmissibility might be challenged only through regular appeal procedure. In such a situation, the party of the proceedings have to prove that the decision regarding the evidence influenced the judgment issued in that case. It's not always, of course, possible, especially if the judgment is supported by other evidence. And I don't have to mention that in some cases, such additional evidence are in fact the fruits of the poisonous tree. And without them, without the primary evidence, those pieces of evidence would not be present in the proceedings. One more thing in that context, the burden of proving that the evidence is inadmissible generally rests with the party of the proceedings, the one that raises such allegations. Usually it is the defense lawyer. Some of the interviewed lawyers during our research noted that the party of the proceedings did in fact not have the opportunity to effectively verify the given evidentiary procedure that had been carried out during the stage of pretrial proceedings. Therefore, the party of the proceedings is unable to make a plausible allegation in support of their challenge. Our study did not provide clear indications whether and how the mechanism of evidence admissibility assessment should look like. However, it proved a need to boost current regulation by establishing provisions that would force courts or the prosecutors to physically remove evidence from the case files. The one evidence that was found to be inadmissible. Currently, such evidence remains in the case file, despite the fact that they were found to be inadmissible. And in our opinion, and in the opinion of some of the judges that we have interviewed, this situation have a potential to influence the way the judge perceives the case. So it can influence the final outcome of the case. And the problem of inadmissible pieces of evidence is not only theoretical. I have to emphasize that during our research, we were able to identify at least several evidence that raised doubts regarding its legality. This includes, first of all, lack of mandatory legal assistance during initial hearings, even in cases concerning suspects who were belonging to vulnerable groups, juveniles, persons with mental disabilities, old persons, so on. Secondly, the problem of bypassing evidentiary prohibition. It is generally illegal in Poland to use as an evidence suspect statements made during interrogation him as a witness, or statements made during informal talks with the police. However, some of our interviewees indicated that it happens that the information from such procedural actions are transponded to the proceedings by interrogating persons who participated in the proceedings. So the law enforcement officers are asked what the suspect has said during the informal talks. Thirdly, identification parades, a piece of evidence that is on one hand recognized as very convincing, and on the other hand prone to contamination. For example, by presenting a witness identification parade in which the suspect vary a lot from other persons participating in the parade. I personally remember a case of a man who was presented in the company of 3 construction workers who were stained from head to toes with paint. Last but not least, the search of premises. Generally, such search should be conducted only if there is a good reason to suppose that the searched objects, persons are in the search place object. In fact, in practice, such searches are conducted regularly, even in cases where there is no chance to find evidence of the crime of the searched person. I recall a case of a man who was arrested for watching women getting changed in the swimming pool, and the police have carried out a routine search of his premises and found drugs. The case ended that he had been charged with additional offense of drug possession. There's a question whether the result of such search should be found to be legal. The last slide, just to sum up, one of the objectives of this project was to increase the mutual cooperation between the member states. Such cooperation is generally based on mutual trust. It's trust that the other states, other than ours, recognize the same standards and guarantee the same rights. I have major doubts whether Poland is still in that context trustful. The amendment to Article 168A, the so-called reform of the judiciary, the increasing polarization among our judges, and in fact the lack of effective procedural ways to challenge the admissibility of evidence, in my opinion, undermines such trust. Such factors should be taken into account while assessing or approaching any European arrest warrants or judgment issued by Poland. This situation should also motivate European Union to urge its actions and at establishing some kind of common standard in that field. Thank you.
Thank you, Marcin. I think that your presentation definitely highlighted some of the key findings that we have made, and of course, based on your information. And one of the cases that stood out that covers a couple of points that you covered is the one where we intervened before the ECHR. It's communicated at the moment where a person was informally interviewed, and then this testimony was admitted through police interviews.
The case Lalik versus Poland, where our strategic litigation program has provided the court with amicus curiae, and the third trial has done the same as well.
Shows how sometimes these statements are giving more credibility on a national level than legal evidence or subsequent developments. So it's very important issues to discuss. Thank you, and I will give the floor now to Professor Michele Panzavolta. He's an associate professor of the University of Leuven, Catholic University of Leuven, where he also acted as a vice dean for internationalization. He's specialized in European and international criminal law and comparative studies over criminal law and procedure. His research interests are procedural rights, cybercrime, intelligence-related topics, and more in general, judicial cooperation. And Michele is a qualified and registered attorney at the Bar of Bologna and has acted for several years as a consultant for the Italian Parliament in matters related to criminal justice. Thank you, Michele, for being here, and the floor is yours.
Thank you, Ilse, for the introduction. And let me premise my talk with some other words of thanks to you, not just as a president, but as a driving force in this project. To Laura, Mike, and all the other people of Fair Trials, and all the partners. It was a great experience for me to work with all of you, all of them, and I really learned a lot from all of them. What I am presenting today are the basic findings of our academic study, more of a theoretical approach we took, as we had in fact agreed upon at the beginning. The findings are the result of research which I conducted together with other people, and I want to thank them here. Elisa Myers and Anna Mosna have certainly helped me out very much. And then I want also to mention that there are some colleagues who before and still now are in the process of helping us with the finalization of the report, giving us feedbacks and other suggestions. Thomas Weigen, Professor Nitu and Zlati, Professor Steinborn, Professor Fanego, and Professor Lopez. So after this long introduction, I will go with further ado to the 3 points of my talk. And they will more or less, in fact, cover issues that you, Ilse, and Professor and the other two speakers have already addressed. The 3 points I want to deal with are admissibility versus exclusion on the one hand. What's the difference? Why excluding and how to exclude? Admissibility versus exclusion. This is a traditionally problematic point. Are these two concepts the same? Are they two sides of the same coin? Which means if evidence has been wrongly admitted, throw it out. Well, I wouldn't say so, because in fact, the concept of admission does not exist in some countries. And this is not just along the traditional divide, common law, civil law, which you also see in the slide, but this is, in fact, several civil law countries have by now introduced formal moments of admission, where there is a decision on all evidence that is to be introduced before a court. But it still is true that there are some countries where no specific formal moment of admission for all the evidence is taken, and particularly when it comes to admissibility of evidence coming from the investigations, evidence which is placed in the file during the investigation and then is handed over to the trial judge. And so for that reason, there is no formal moment of admission for that evidence in some cases. So why do I say this? I say this because, of course, admissibility and exclusion have somehow a different function. And if some countries do not have that formal moment, there might be a confusion or misunderstanding. We might think that admission is the moment when evidence is placed in the file during the investigation in one country, whereas in another country, admission is the moment in which evidence is requested for production before a trial court. And those two moments are clearly very different. There are also other differences between admissibility and exclusion that we want to point out. So admissibility might have different meanings, but it's also different from exclusion, because admissibility normally looks ahead when it takes place, whereas exclusion looks behind. Admissibility is concerned not only with evidence that already exists, the production of a document exists before its production, of course, but it is also concerned with evidence that still needs to be collected. For instance, when a testimonial deposition is requested in front of a court, then that testimonial deposition still has to take place. Now, of course, a different thing would be the production of the minutes of records of a prior questioning during the investigations. Exclusion, instead, is concerned only, or mainly, I would say only here, with evidence that has been collected. Now, this carries another difference, that admissibility never, or should never, entail an assessment of the exact piece of evidence and its reliability. There is an assessment of its relevance, maybe, but not of the evidence as such, and what its effective probative value in the case is. It is more or less a judgment looking again ahead and thinking how much of this evidence, how much of the information conveyed by the evidence can be useful if used by the court. But exclusion is different. Exclusion can entail and sometimes even require an assessment of the exact piece of evidence. What is it? What kind of specific information it carries? And it can even entail reliability, whether or not we think that is a good thing. Now, in essence, and to summarize, exclusion and admissibility are two things, but exclusion is larger than admissibility, has slightly different logic. Now, this does not mean that they're not connected, of course. Exclusion is connected to, and it is affected by, admissibility. And this is inevitably so, because if admissibility expands, I mean, the area of exclusion shrinks. Well, it doesn't really shrink, in fact. It's just that the separate autonomous area of exclusion shrinks, but the area of exclusion remains unaltered, simply because if the filter on admissibility is greater, then, well, the cases in which evidence is excluded, say for the case where evidence was wrongly admitted, well, the area where evidence is excluded, being legitimately admitted, is more limited. You know, there can be cases, for instance, in a court hearing, a witness is heard during a testimonial deposition, and the testimonial, the collection of the deposition of the witness is made in a way that affects the evidence. You know, maybe improper questioning, threatening by some of the counsels asking questions. You know, these things could happen. These are issues that do not affect admissibility, but they do affect exclusion. This is why we have taken, in the end, a stronger approach, at least in our theoretical part, on exclusion. Then the real question is why exclude? And I'm going to say here things that are known to the audience that is present today. So forgive me if I repeat things you already know, and if I say things that are rather trivial, of course. But I still think it is important to understand why we exclude. Sometimes in some countries, we just find ourselves in front of the provision of a book, of a code, which says exclude evidence in this case. And we don't even bother that much about thinking why that is. In other cases, we have to wonder why that is, because maybe where a judge is taking a decision and so has a margin of maneuver. There are, I think, 4 questions we can ask. Do we exclude because we want to ensure that the innocent is not punished? Well, this is one thing which is different from protecting and restoring fundamental rights, because those fundamental rights could be even of people who are guilty. Do we do it for preventing violation of fundamental rights, which could be something different and is something different from protecting and restoring? In fact, we could say, well, you know, we want to avoid that they take place, and we do not only want to react to the violation that has taken place. Or more in general, more in large, we could say we want to uphold some fundamental principle of justice and ensure the integrity and legitimacy of judicial adjudication. I'm not going to say which approach should be favored, and I think there can be many combinations, and the results of our study and the results of the report of fair trials show that, in fact, they can be combined. The one thing that is important is to be aware that we should be consistent in adopting one or more of these principles and a specific combination of this principle. And we should also be consistent considering what the logic of each principle is and what it entails. And I'll try to go briefly over these 4 main rationales. Now, the reliability logic is the one for which we do not want that an innocent be punished on the basis of evidence that is false or totally unreliable. Now, this goes back to truth finding. We want to find the truth. If the person is innocent, the person should walk free. Now, this entails, of course, that on the one hand, we exclude unreliable evidence, but on the other hand, we make all reliable evidence available to the court. Now, the two things are not exactly the same. And we, in fact, have pleaded for one approach, which says, let's take the reliability principle seriously, but not too seriously, which means we want to exclude evidence that is unreliable, of course, but that doesn't necessarily mean that, by the contrary, we want to admit all evidence that is reliable. I think in this respect, our position, the position of Judge Pinto de Albuquerque, are in fact very much in line. But there is another question we have to ask ourselves, and that is, how do we assess unreliable evidence? Now, it seems easy, but it really is not. Now, first question is, should we look at the information as such or at the way in which it is produced? These two things are not exactly the same. I put here as a form of example 2 very different kinds of exclusionary rules. The bad character evidence, which by the way is an exclusionary rule that does not exist everywhere, and illegally obtained evidence, which is kind of more globalized. Bad character evidence is exclusion of information on the basis of an information as such. It is considered to carry too much probative value compared to the case at hand. whereas illegally obtained evidence is exclusion of evidence for the way in which it was collected. Now, these two things are different. I believe we could take both approaches, in fact, and a lot of countries, in particular those who follow the best evidence approach, well, they certainly try and combine both. But again, if that is the case, we need to be sure on what are the cases we want to cover. The second question is, if we're looking at the way, at the assessment of the unreliability of evidence, should we do so in abstracto or in concreto? Does it mean, should we look at whether evidence obtained by certain means or in a certain way in general is unreliable? I can, for instance, say every time there has been torture, evidence is per se unreliable, although this might not necessarily be true. In fact, sometimes there are extorted confessions, there are true confessions, but I can say, look, I am assessing this in abstracto, and in abstracto, I believe torture taints the reliability of evidence automatically. Or I can do it in concreto, and in concreto, of course, has some advantages because the courts are left with the job, with the tasks, at least advantages for us lawyers, theoretical lawyers, and the judges are supposed to look at all the circumstances of the case and maybe measure that specific piece of evidence against other pieces of evidence and find out that that piece of evidence is unreliable. Now, this second approach is probably the easiest, but I still believe that we need some basic epistemological choices. And that means that we need some basic in abstracto rules on reliability. Then disciplinary logic, probably the most discussed one, as you know, because it is intended to prevent violation of right by removing incentives for violations. If the police, the prosecutors, if they know that the evidence that they collect in an improper manner by violating fundamental rights is not going to be used by a court, well, then they will not be willing to go down that line. They will not be willing to violate those rights. Now, of course, you all know that there is a never-ending discussion of whether this is effectively true or not. And yeah, well, there have been studies going in all sorts of directions. And we do know that in some cases, maybe the existence of an exclusionary rule can change the rational, the reasoning or the approach of the police or the prosecutor acting at certain times during the proceedings. But there are, of course, a lot of other factors that impact upon the choices that are made when conducting investigations and trials. Another question is whether there are also other remedies which could have the same disciplinary function without depriving the trial of reliable information. And of course, this is, I believe, a rather strong argument in this respect. But the last question is whether this is at the very end appropriate. So is it appropriate that we use the rules of criminal law and criminal procedure in particular to punish, whereas we normally have other branches of law? There are a couple of elements we need to consider when we look at the disciplinary logic. I mean, if we want to punish people or prevent violations by punishing people or by threatening people with possible punishments, in this case, the punishment would be the exclusion of the evidence, by the way, and I'm not sure that would qualify as a form of real punishment. But if we do so, well, then it is inevitable that we need to look at the intention behind the transgression. Was there a violation that was clearly intentional, or did it happen just by accident? And then we open up the number of exceptions that we all know of, and that have been mostly introduced by the US Supreme Court, because the US Supreme Court for quite some time, as far as I know, used this rationale, then kind of slightly moved away from it. And this rationale works best for public authorities, but not necessarily for other authorities. The protective logic says, if a violation of a right has been suffered by the accused during the proceedings, then the accused should be restored. For instance, an unlawful interrogation, well, then the unlawful interrogation should be thrown out, and the accused should be, the case against the accused should be decided without that interrogation. And likewise for an unlawful search in the house of a suspect. This protective logic says, you have violated a right, and exclusion protects the right by removing the violation, right, or the consequences of it. Now, the question is whether this is in fact always proportionate. It works only for some violation, not for, the gravest violations. Imagine a confession extorted by torture. I would believe that is a case where the entire proceedings inevitably are tainted, and not an exclusion of evidence would probably be insufficient in that case. And for minor violations, very, very minor violations, maybe even formal violation, one could say, well, excluding evidence in this case is too much. Plus, it works only for the accused. So if there is an unlawful search in the domicile of the third parties, we cannot say that we're using the protective logic by excluding evidence. If the third parties are the victims, we're actually doing them, we're actually doing something totally wrong. We're actually not doing them a favor. And this shows in a recent judgment of the European Court of Justice, which I'm sure you all know of, the judgment Procurateur, where the court concluded that in case of an unlawful mass collection of traffic data, well, the evidence is to be excluded for protective reasons. Now, it is true that the court reaches adopts the protective logic also on the basis of specific principles of EU law, effective protection of EU law. So maybe that might have had an influence on the reasoning, but the protective logic here does not hold, because excluding the evidence does not restore society for the unlawful mass collection of data, and at the same time might actually do a favor to the accused. The last approach is the judicial integrity logic, and that is to ensure legitimacy of justice and justices in the eyes of public. Make sure that, when justice is done, everybody can see that it is done. And so if there has been a violation of fundamental rights, and it's a serious violation, that cannot just be accepted or tolerated, because that would undermine the credibility of justice and of those who do justice. This entails an overall balancing of violations that have taken place in the collection of evidence with the public interest and the moral integrity of the justice system at large. Now, of course, you will see this is a very broad definition, and in fact, it entails a very large discretion. And it is sometimes difficult to identify what the elements of integrity are. So I come to the last point, and that is, well, given all these elements, what's the shape of an exclusionary rule, or of many exclusionary rules? Again, not necessarily only one. Should we go for an approach favoring a strictly construed rule, and maybe in codes, in criminal codes, or should we instead leave more flexibility to judges? Or a middle way approach could be we actually write a rule in books, which though gives sufficient leeway to judges to appreciate the circumstances of the case. Now, I think you have understood that all principles have some downsides, but all principles that I mentioned, all different logics, they have positive sides. So it would be wrong in our view to take some of these principles out. But of course, some principle, the protective, particularly the integrity principle, they require greater judicial discretion. Now, I know this might be a problem of compatibility with system based on strict legality, but I still think that even system based on strict legality can, in fact, to some extent, accommodate a rule that is slightly broadly that is worded in a slightly broader way than the traditional strictly construed rule of, for instance, some civil law systems. And of course, at the same time, when we give discretion, we should make sure that this does not affect the effectiveness of the goal we want to achieve, because of course we know that in large balancing exercises, judges might be tempted to choose one way or the other on the basis of what is in the end a rather unclear approach, and this might in the end frustrate the ultimate goal we want to reach by excluding evidence. And this is exactly, and here I am simply showing what I believe Judge Paulo Pinto de Albuquerque said before, and much better than me. This is the danger of the holistic view, when there is too much discretion involved and everything goes into a big mixer, the safeguards, the violation, the compensating and remedial factors, and they all boil down to, is the fair trial, and by the way, the fair trial of the accused only or of all parties, is the fair trial protected? Well, when we do this, when we look at the proceedings as a whole, we run the risk, in fact, of allowing too much discretion. So here, and I come to my conclusions, we've seen that there are different logic and ideologies behind exclusionary rules. And of course, no exclusion can kill fundamental rights, but at the same time, and we must acknowledge this, too much exclusion can be detrimental, though I believe this does not happen in real life today. It's not a real risk we're running. But at the same time, no discretion can be detrimental when excluding, and too much discretion can be detrimental, because a case-by-case approach in the holistic view we just discussed could in fact cause fundamental rights to fail. So finding individualized solutions carries in fact inherent dangers. That's why we think there is a need for guiding discretion. And that's why we've reached this approach in guiding discretion, when we look at the reliability principle as the basic core and principle for exclusion, which means evidence that is unreliable, in concreto, sure, but sometimes even in abstracto, and we need to discuss the choices we make there, that evidence is to be excluded. But then next to that, there is a second filter, which is the protective. and the last one, which is the integrity. And it all boils down to the beautiful chart that Ilse already summarized and discussed, and with the minimum mandatory exclusions that the beautiful report that Fairtrade has drafted incorporates. Thank you so much for your attention.
Thank you very much, Michele, for your very interesting insight into the more foundational principles. It is also the observation in our report that judicial reasoning is lacking all these principles, choices, and revealing the principles behind one or the other choice with unlawful evidence. And this is partially this leads to incoherent court practice. So what we can do now is to move into the discussion part. We have a couple of questions. We have two questions for Professor Pinto de Albuquerque. So I'll start with the first one that was asked in the Q&A. And it's a bit it's a bit a more broad question from Fabien, who's going to be on the second panel today, and he asks, how do you explain the restrictive case law of the ECHR on the admissibility of evidence? What would be the reason for such court's approach?
Well, my view is that the court does not want to engage in a diplomatic fight with the Supreme and Constitutional Courts of some member states, including Italy and Germany. These are very.
Sorry.
These are very. Should I continue?
Sure. I'm sorry. I forgot to mute myself.
When a Supreme Court or a Constitutional Court of Italy or Germany speaks, it's extremely difficult to argue against them, and the judges feel that they are actually, in some cases, pressured, I should say, just to go along and to avoid any embarrassment, to put it mildly, with these courts. These are powerful voices in Europe, and in fact, much of international justice is about politics. It's about diplomacy. It's about avoiding disputes and confrontation between courts. Here, of course, it's an important point that should be taken into account, the fact that if you have a very strict guidance from Strasbourg, you, of course, limit the discretion of the Supreme Courts and Constitutional Courts, which would inevitably lead to confrontation. So it's very tempting to avoid this confrontation by simply allowing as much discretion as possible, especially in these highly sensitive criminal procedure cases. So it's also about politics. It's also about international politics. It's also about judicial diplomacy. If you add this, the fact that some of the members of the international courts, including the European Court of Human Rights, they come from the national judiciary, then you have the perfect environment to come up with this result. this case law is the fruit of all these considerations, I would say, and I would not add anything more.
Thank you. Yeah, that is a very tricky question with the regional courts and their role and how they of course also have to keep cooperating with member states to continue their operations. One question that I wanted to ask Michele is, you mentioned you addressed the issue of admissibility versus the exclusion. And from a practical level, one of the conclusions or observations that we make in our report that there is a rarely in civil law systems an admissibility stage. So the focus is naturally on evidence that is already in the case file at the trial stage, where the judges have to exclude evidence that they are already familiar with by receiving the case file. Do you think that if there would be more focus on the admissibility stage, especially pre-trial, or even a specific procedure for that, do you think that could solve a lot of the problems that we subsequently face when it comes to exclusion in trials on merits?
Right, thank you. If I understand correctly your question, and it seems quite tricky, you're asking me if it would be okay to have a sort of filter or control before the trial stage?
Yes, it's more of a, because the admissibility stage rarely exists as a separate stage of evaluating evidence, right, with the purpose of admitting. Do you think if there were more focus or even if there were specific procedures for that developed, because now it's an implied,
the introduction of similar moment, I think it would help. Indeed, it definitely helps. I must say that, of course, countries that do not have systems of admissibility, formal moments of admissibility of evidence, have in fact other ways to deal with this. There can be moments of filtering before the trial by excluding evidence that is tainted. But in general, I believe that yes, if there is a scrutiny at some point and at some moment before the trial, at the very beginning of the trial, on whether evidence is to be admitted or not, I think this would very much help, particularly, simply the scrutiny on the case file in order to look for violations or other possible problems. So I do think that would certainly help. Although I also believe it's not necessarily an easy mechanism to introduce everywhere, because the shape of the unfolding of proceedings in some countries is such that introducing a moment of admissibility would require quite significant changes in the procedure. But yeah, I would favor that very much. I think, as I said, if the filter of admissibility, the greater the filter of admissibility, the less we have to rely afterwards on exclusion. We still have to rely on exclusion to some extent, and inevitably so, not least so because some evidence is wrongly admitted. So in violation of the rules on admission. But the strongest admissibility, the strongest the protection in general on the four fronts that I mentioned.
Thank you. There was another question asked about exceptional circumstances in which the unlawful evidence could be used. I think that question was addressed to Professor De Albuquerque, because you mentioned somewhere in your presentation that there could be exceptional circumstances, and a participant is asking, what do you think those could be?
Well, I would say that one thing that we should not do is to reason on the basis of exceptions. I think in order to give clear guidance to the national courts, we should establish, the court should establish, the European Court should establish clear rules. Clear guidance comes with clear rules. And what we do not have today is such guidance. We have a very casuistic case law which takes into account basically the nature, the very severe offense that is at stake, and that would allow for all sorts of bargaining with between the police and the defense, allowing and condoning for police misconduct in some cases. And we have seen this in particularly sensitive cases like terrorism cases. Ibrahim is such a case. I think it's a danger to reason on the basis of exceptions. But of course, rules also have exceptions, and even if you are not willing, as I think we should not be willing to accept this overall fairness assessment, we should in any event allow for such general assessment in a particular circumstance. What I have written in Murtaza Aliyeva is basically that when a judgment and a national judgment does not violate any of the requirements of Article 6.3, it still can be unfair. So the overall fairness assessment can still be done and should be done. What cannot be done is the opposite. So if you have a breach of any of the guarantees of Article 6.3, and you come up with a violation of one of these guarantees, you cannot cure that violation and say at the end of the day that this is a fair trial because overall the end result is fair. This is absolutely not admissible, and this is done especially in these very sensitive, highly politicized cases like Ibrahim. So, in my view, I very much appreciate the civil law approach, which is stating clearly, black and white, what are the red lines that should not be crossed? These absolute rules that cannot be compromised. And if they are there, if they are reached, then you have two possible results. First, inadmissibility of the evidence. Second, if the evidence was admissible, or admitted, if the evidence was admitted and considered as a basis for the conviction, then the nullity of the conviction. This was the case in Dvorsky, for instance. The three judges who wrote separately were pleading exactly in this direction. Is there room for the court to state beyond the rules what are the exceptional cases where illegally obtained evidence can be considered? Yes, of course there is. Yes, of course. This is an exercise that any national court does, and the court has done so in a couple of cases where it was, especially chamber cases, where it made this effort. And my view is that if the court went down that path, that would be good for the clarity of the case law. So to state clearly that the breach of these absolute red lines lead necessarily to automatic violation of a convention right or freedom, and cannot be the basis of a conviction. And with regard to rules that cannot be understood as absolute rules, which are in fact, so to say, negotiable, these evidently are to be complied with in accordance with the requirements of the convention, namely Article 8, number 2. Here there is some room for discretion. There is some room for for a sort of proportionality test that would eventually save the evidence and eventually save the conviction based on that evidence. So my point is basically that the court should clearly state, as the Supreme Court of the United States has done, which are the absolute red lines that cannot be crossed. Okay. And these would not allow for any kind of negotiation. There cannot be any reasoning on the basis of what Judge Scalia was calling harmless error assessment. With regard to these basic foundational rules of criminal procedure, there cannot be any such harmless error assessment. Outside of this core of the criminal procedure rules, of course, there's room for a proportionality test. There's room for an assessment of the needs of justice, and it's up to the court to define the limits of this test. It has done so. It has clearly indicated in some cases that there are procedural defects that do not lead to a finding of a fair trial, and so the court itself decouples these procedural defects from the end result and from the fairness of the trial. To sum up, I think what we need here is not a lex perfecta, but an effort from the judges to do a better work in terms of definition of what are these basic foundational rules that cannot be breached.
Thank you. We've thought about this also from the EU perspective. It's a little bit different with the European Convention of Human Rights because its role is a little bit different, and it sets a minimum standard in national states. We've thought about common rules in the EU, where especially in the context of mutual cooperation, it is a maximum standard rather than minimum standard, and we see a lot of risks in creating common standards in substantive standards on admissibility or exclusion in EU level, as they risk to lower existing protections that exist right now in national contexts. So we have abstained from advising common substantive rules on admissibility on the EU level. But that being said, on national level, they are very useful guidance to the courts. Another question that is being asked is whether there are pretrial hearings and admission of evidence before a different judge in national states. We saw that practice, that there is a sort of exclusion/admissibility phase in Croatia. Marcin, can you perhaps tell us whether there is such an admission of evidence pre-trial before a different judge in Poland?
No, it does not happen. Usually the admission of evidence is made by the court who will be recognizing the main case. So it happens that the admission of evidence is about used to admit that the evidence that will be useful for the court in convicting or acquitting the person. Because usually the courts in Poland have an approach to the case when the indictment is brought to the court. That's their first impression on the case, and it generally ends with conviction. About 98% of our cases brought to the courts ends with conviction. In fact, such procedure would provide the system with an impartial approach to the problem of admittance of the evidence. So I think it would be a good solution to introduce some similar regulation. Of course, we have to take into consideration that it requires additional efforts from the justice system, especially in the context of Poland, where the backlog of cases is huge, and that's the problem of it is a huge problem of judicial system that might be an issue while discussing the implementation of such solution.
Thank you. So there's a varied practice, as we can see, on domestic level across the member states. There's a question to Michele. It's probably relates to the CJEU cases, but the question is, what about fishing expeditions? Should evidence obtained from fishing expeditions, that would probably mean just general either surveillance measures or just a gathering of data outside criminal investigations, concrete criminal investigations, should that evidence be used? A participant asks.
So the hard and fast answer is, of course, no, and everybody knows that. And I think I would be willing to defend this answer in the large majority of cases, maybe all of them. But mostly because, of course, fishing expeditions are a violation of the fundamental rights involved in and that have been impacted upon in the fishing expedition, be it telephone tapping or computer tapping or house search or whatever else. I think this can be in the context of an integrity approach. It could and should be excluded, but it is the integrity approach that comes into play. And there's a couple more words I want to say about this, just so that we're clear, because it is true we are pleading for discretion here. But I'm not pleading for discretion, and I think none of us here is pleading for discretion, believing that, well, should be left in the hands of judges and let them do whatever they want. Of course not. That's exactly the point. I believe, too, that there should be some red lines, if we want to call them that way, or, well, the way we call them, epistemological choices on the one hand, which nobody has made, though. I have not heard many people tell me when evidence collected in a certain way should be excluded because, hey, that's an improper way, besides the torture case. The hearsay point, for instance, I mean, hearsay is an example of evidence. I don't know if somewhere in between evidence excluded because of the way of the information as such, second-hand information. And, but you could also say it's the way in which somehow the information is surfaced. The hearsay rule is not applied in many countries, actually. There's plenty of civil law countries that actually do not ignore it for the most part. I think that's an example of an epistemological choice that we make. I don't want the case to be decided on second-hand evidence, and that yet we do accept that on a regular basis. I think this is what we have to do, not just looking at rights, really. We're looking at rights, basic rights, but also looking at how we produce knowledge in trials. So those red lines are important to me too. I think it's difficult though to find them. And even if we find them, I believe we would be able to defend them as absolute only in very few cases. And what troubles me most is that if we insist on having so strong and absolute rules, we might end up with having none. So I'd rather have some rules minimum that are really not negotiable, if you want to say so, and maybe torture can be one of that, and maybe even inhumane or degrading treatment. But that's not even true in the case of the European Court of Human Rights. There are exceptions there too. So I'm in favor of that. But I mean, I think we should start looking at the second step, which is give some discretion, introduce discretion, and guide the discretion. Avoid that the public interest analysis is the first element that comes into play, because then, of course, if the trial is a mafia trial and the violation is not the most serious violation one could think of, the most outrageous violation, then it will be condoned. So it is important to say, look, you need to look at this first and this first and this first. Then I understand it will be for judges to motivate, and maybe they've made up their minds in totally different ways, but I think at least it would be something to force them and not to allow them to put everything in one big box, as I said. So I think in that respect, the discretion is helpful. Now, this being said, fishing expeditions are one of those cases where the detriment for the entire society, as in the mass collection cases, is such that I think any sensible judge would, in the end, when looking at this, would probably reach that conclusion. But I cannot, I mean, again, we should really, I mean, fishing expedition, well, it depends, you know, if you've searched 300 places, 300 premises, really hoping to find something and there was no clue whatsoever, or maybe there was a little bit, and, you know, there was a minor violation, you know, the intensity of violation should be looked at times. So I think there is there are some elements that have to be taken into account. This being said, the more we guide discretion, if we say, you know, if it's a fishing expedition that affects a large number of people, and that's a large violation, well, it should not be condoned, of course, absolutely not. But so I think this is the point. And as we come to, I think there was another point on reliability of evidence, if I can just add a word on that, Ilse.
For sure, yes, sure.
Right. Yeah, I think the question was, why exclude unreliable evidence? If it's unreliable, I'm not going to use it. And that's a very sensible remark, I think. But this is true for unreliability in concreto. So I realized that the testimony of Mr. X is absolutely false because Mr. Y, Z, and documents actually prove the opposite. So in that case, there is no doubt that I would not, any sensible judge would never use that. When it is done in concreto. If it is done in abstracto, that's a different thing, in fact. You know, if I say that every time evidence is collected in a certain way, for instance, I mean, let me come up with an example from one country. There is one country, and those of you who come from that country will probably recognize it, where it is said that questions that are threatening or can have a threatening form actually require then the exclusion of the deposition that has been collected in consequence of it. Now, even one question can be threatening as such in what, 10, 20, 100 questions, okay? So this is to give you the idea of, you know, how much in detail we could go in making epistemological choices. We can say, you know, we want even to regulate the reliability in the way, meaning the way in which the evidence, reliable evidence, is formed. So when that is the case, well, then it is not so straightforward that evidence, unreliable evidence, is to be excluded. Unreliable evidence in abstracto, for instance, obtained by means of torture, could in fact be true. There have been cases, and many cases, where extorted confessions were true. I mean, does that condone the fact that they were collected by torture? I don't think so, right? So that's why I think we do not only have to look at reliability of evidence in concreto, but in abstracto. This means making some red lines, not just with the rights that we want to protect, but also with the way in which we find the truth. And I think that's the part where we lack the most. We don't discuss this really, and we leave it to the national sensitivities and often the sensitivity of judges. And the last point is, it could also be useful, reliability of evidence, when the decision, the panel taking the decision, the court taking the decision, is not the same, excluding. So there are countries where exclusion can be made at an earlier stage. Unreliable evidence, clearly unreliable evidence, evidence that is utterly false, can be thrown out before. So in jury trials, it could be thrown out by the president in order to avoid that the evidence has further psychological impact on the jury. So in that respect, it can be useful, even more in general, to have to put reliability within exclusion. Sorry for taking so much time.
Oh, no problem.
If I may,
Sure.
if I may add something.
Yes,
With regard to this issue about the fishing expedition, I would like to draw your attention to the recent case of BBW, Big Brother Watch versus United Kingdom. It's a Grand Chamber case of this year, delivered a couple of months ago. I was a member of the composition. It was in fact my last case at the Grand Chamber. And it is exactly about this, about the firewall between the intelligence gathering on the basis of these fishing expeditions and the criminal procedure. What law enforcement agencies can take from this data that has been collected basically for intelligence purposes, and then what they can take to criminal procedure. In some countries, like for instance Sweden, which was the respondent state in one of the cases, so these are two cases, Big Brother Watch versus United Kingdom and Rättsvisa versus Sweden. In the second case, there was this firewall, this separation, strict separation according to national law between intelligence gathering and collection of evidence for the purposes of criminal procedure. But there is no such separation, for instance, in the United Kingdom. And the problem here is, of course, that if you go into these fishing expeditions, then you are ending up with evidence that is collected on the basis of a general suspicion on every citizen. So there is no individual suspicion. There is a suspicionless collection of evidence that may target you or me or any other citizen. And this the court has already refused in the framework of criminal procedure, okay? Roman Zakharov versus Russia, it's a Grand Chamber statement, very clear, where the court says fishing expeditions in the framework of criminal procedure are not admissible. This is one of the red lines. This is one of the structural errors that taint all the procedure. Not only the piece of evidence, but the conviction based on that piece of evidence. So the court makes that effort when it wants, finding out these structural errors, these epistemological choices. They are done in the case law of the court, where the court really defines very clearly in very black and white language what cannot in any event be admitted. Roman Zakharov is such a case. Fishing expeditions in the framework of criminal procedure are simply not tolerable. Now it comes Big Brother Watch. Big Brother Watch is not a criminal procedure case. It's a case about intelligence gathering. And the court sends out a message that is so vague, so in fact, how should I put it? The court wants to please the national authorities. The court wants the national authorities to think that they can fight back against terrorism with whatever means necessary, including these kind of fishing expeditions, mass surveillance in the case, internet mass surveillance, and does not have the same courage of the Roman Zakharov majority. The Roman Zakharov composition was really very clear in the statement made. No fishing expeditions, no mass surveillance for the purpose of criminal procedure. When it comes to Big Brother Watch, which might have been the best ever occasion for the court to send out a clear message with regards to intelligence gathering, the court misses the point and fails the opportunity. It misses the opportunity and really allows for a very nuanced message, which will, at the end of the day, give a lot of discretion for the national authorities, not only to collect this evidence for the purposes of intelligence, but also for the purposes of criminal procedure, which is the case in the United Kingdom, not in Sweden, but in the United Kingdom. At the end of the day, what we get is that we have a mixed message. Roman Zakharov says one thing, and then Big Brother Watch, the subject of the case is a different subject. It's about intelligence gathering. But since the respondent state in that case, in Big Brother Watch, did not have this clear firewall between intelligence gathering and criminal procedure, it will end up being understood, and has already been understood by the national authorities, as allowing for this evidence collected in mass surveillance cases to be also used in the framework of criminal procedure, which is the absolute opposite of what Roman Zakharov concluded. Some people have criticized the court of double standards. You have for Eastern Europe one standard, and for Western Europe another standard. It's almost blatant. Why to reproach Russia for doing these fishing expeditions for the purposes of criminal procedure, and not to reproach the United Kingdom when there is the same exact problem? And here, of course, it pops up as a possible reasonable explanation that the court has double standards. Western Europe is dealt with in a different way from Eastern Europe. I'm not going to enter into this because I think it should deserve the attention. It should deserve the attention of the academic world. It really should deserve the attention of us all, professors in the universities. This issue is one of the issues where this discrepancy in the case law is so evident that is really very difficult to explain, and therefore it should really be the object of some reflection.
Thank you so much. And that brings us to the end of the first panel. And of course, I mean, with all these discussions, we have seen the limitations of the current practice, and also the implied reliance on ECHR as the panacea for all the gaps and all the lack of guidance that we have. And we can see that it has clear limitations. There are some good standards, but then the consistency, and also in some cases just the standards as well, are not very clear and not applied clearly, and yeah, with all the shortcomings that we've discussed. I'll be very happy to see the participants in the second panel, which starts at 1:30. You have received the link in the chat, but also in the emails before. And let me thank you again to our panelists today. Lots of good food for thoughts, and I'm hoping that your interventions, as well as our report, is just the beginning of discussion and not the end of it, and which will go on and hopefully will help judges on the national level to make the decisions that are principled and preserve fundamental rights and legitimacy of the criminal justice system. Thank you, and see you on the second part of the day.